corporate law for the next 4 years, where I worked with medium to large enterprise clients, had an opportunity to work with a startup client on a financing and recapitalization of their company. And that really drove my passion to work with entrepreneurs and founders. In 2019, I cut ties with, the, stodgy, typical law firms that I worked with who didn't want to represent startups. Started my own firm, Fridman Law Firm, and we exclusively represent startups and founders in a variety of different industries and spaces. But I love talking to founders in particular, because a lot of what I do, especially when I meet a company, early on, is often cleaning up some things that were done or could have been done better from a legal standpoint, and also in the eyes of investors. And that's really my goal as a startup attorney, is to make my client companies look attractive to outside investors if they're looking to be venture backed, or if they're potential acquisition targets. So I wanted to start off by discussing some common pitfalls that I see sort of over and over again in my practice over the years. And, one of the biggest thing is selecting, a name and a logo, or, forming your entity in that name without doing a proper trademark clearance search, because a lot of times companies will just choose a name, fire up a designer to get a logo going. And then, they find out, once they start commercializing and bringing that product to market, that they're infringing on someone else's rights, and they're getting hit with a cease and desist letter. And that often results in a whole rebranding of the company, and doing another trademark, search and filing, and having often spent money on marketing agencies. You may need to do that all over again. So I always advise clients, first and foremost, to seek the assistance of trademark counsel, just to at least run an initial search in the USPTO database, the US Patent and Trademark Office, and also do a online search as well, because there could be both federal and state rights to a trademark. And the next biggest thing that I see, especially with companies that are, come to me and they say they want to raise capital within the next 6, 12, 18 months, and they're going to rely on venture funding to, scale their business and grow, is choosing the right entity. And that is often a discussion that involves thoughts about taxation issues, because in the majority of cases, I'll say, if you want to be a venture-backed company, give equity incentives, raise money using, sort of the conventional documents that have been prepared with C corps in mind, that's fine. But in some cases, you may be putting in significant money up front, and maybe being a S corp or an LLC could be the right thing for you. But we get a lot of clients that come to us that are LLCs that should have been Delaware C corps, because of investor preferences, because of tax benefits that investors get, from qualified small business stock, and giving equity incentives. So that alone, speaking with an attorney about that decision, whether to be an LLC, S corp, or C corp initially from the start, can save you thousands of dollars. Because if you become an LLC and need to convert, either because you down the line you're going to be raising capital, or in anticipation of an imminent raise, that could have saved you money had you spoken with counsel. So those are two really big things that I always harp on and make sure founders are aware of. And I think apart from the entity choice decision, stock issuance matters are really important. And most startups that are C corps will issue, stock to the founding team, advisors, consultants, and employees. And if you were going to be subjecting any of these shares to a vesting schedule, it's very important to file an 83B election, because you only have 30 days from the purchase of that stock to file that with the IRS in the office where you file your personal tax returns. And this could save you huge amounts of money in the future, because you're essentially recognizing a low fair market value for the stock when you purchase it early on, often at several decimals out from a penny for the par value. So you can recognize that you paid for those shares and it was a low value, and you recognize the zero gain on that. But if you fail to file the 83B election and your valuation continues to increase and hopefully skyrockets, it could cause significant tax consequences for any shareholders subject to vesting, and in particular for founders who have a lot of stock. So I think those are a few of the initial issues that I see arise in our representation of tech startups. And the next sort of big area of pitfalls that I see is not having the right agreements in place with third parties. So if you're thinking about bringing on a development firm, you should have an NDA in place just for the discussions of your business and your technology with them, because you don't want that developer or other third party to misappropriate your idea or your technology. And then furthermore, you want to have a development agreement in the case of a developer where it clearly spells out that any technology that's developed by the third-party developer is owned by the company. And to the extent the developer uses their own technology in what they've developed for your company, they grant the company a license to use that in perpetuity, without any royalties or anything like that. And this is really important from the eyes of a potential investor or acquirer, because they want to know that the company owns the technology and that technology could potentially be patentable. And that's another area that we could discuss, but it's very important to have those agreements in place, not only with a developer, but also have an agreement that's goes by a few names, confidential information invention assignment agreement, or it's sometimes called a technology assignment agreement. And you want employees and even other contractors to sign versions of those agreements saying that anything that any ideation, invention, or anything that someone comes up with in the course of their employment or engagement with the company is owned by the company, and that they assign all of their rights in that technology or those ideas to the company. So one of the big things during due diligence, whether financing or acquisition, is really looking for those documents and making sure that employees and relevant contractors have signed those agreements. And I think that the last point I want to make is sometimes people don't put enough emphasis on trademarking and patenting things, but from the eyes of investors, those are assets and have value, and it factors into the valuation of the company. And I've had companies that have patented things that they later on were able to license, and it developed another revenue stream for them, actually. So it wasn't just a exercise in futility, but it had real tangible results. and it is looked upon very favorably by investors and taken into account in the valuations. So I think it's a very important thing to think about. And I'll stop there. Are there any questions on sort of these initial pitfalls before I move on to the next topic?
Do you have a patent background, or is that?
No, I don't. So patent attorneys are highly specialized attorneys. They actually have to have a Bachelor of Science degree before going to law school, and then they take the regular bar and then a patent bar. So my firm does IP law. We do trademarks and copyrights, but for patent attorneys, we use external counsel that's appropriate for the type of clients that we have. So you would always want to discuss that with a patent attorney. Okay, and the next area I want to touch upon was setting the company up for success, and for success in terms of getting investment. And from my experience, having discussions early on with investors, and starting from the friends and family stage onwards, is best to be done early as possible. Not only to let investors know that you're what you're working on and developing, which can lead to warm introductions when you go to raise capital, but I think it gets you in the mindset of having to wear your investors hat and see what's important to investors and what's on their minds, and get to know the landscape. But from a legal perspective, I think that having a certain set of what I call the standard incorporation documents for a Delaware C Corp, for instance, is really important. That's something that would be in the data room. So that would mean having all the appropriate initial resolutions that appoint the board of directors and appoint the officers of the company, all the stock issuance documents, so stock purchase agreements for founders and early employees, the confidential information invention assignment agreement that I mentioned earlier, and other various board resolutions that you may need for your good corporate governance. In terms of overall compliance, people think that an LLC and a corporation are so much different, but in reality, a corporation only requires one board meeting per year. If you're a Delaware corporation, that can be done telephonically. So there really isn't that much more corporate governance, but there is a little bit more, but it's not something that should cause you to shy away from becoming a Delaware C Corp if that's appropriate for your business and what you're looking to do. But having those documents in place, and also the right agreements with employees in place, is very important. If you have a payroll, making sure that you appropriately register with the state, and make sure that you're withholding and collecting the appropriate workers' compensation withholdings for your employees. That's very important, because I see a lot of new companies that take on employees, and they may not engage a payroll processing company like ADP or Gusto right away, and then they get hit from the Department of Labor with fines and penalties for not having the right withholdings in place. So that's something I definitely recommend outsourcing, and there's dozens of startups like Gusto out there that can streamline that process for you. So I always recommend clients do that, because they also make all these filings on time, because there's continuous compliance requirements and filings that you have to make, and they keep your workers' compensation insurance up to date and integrate with them. So I highly recommend doing that, and that should really be another pitfall that I mentioned. But that would be a red flag for investors. But if you have, the standard corporation document set that I mentioned in place, and other, good corporate governance and maintenance of your cap table, and keeping that clean and up to date, that will look very good to investors when they go into your document room, along with, the last point I'd make there in terms of documentation is having minutes from your board meeting as well, because investors will want to see that. But in terms of cap table management, from the very beginning, when you issue shares to founders, you should have at least a basic cap table. It could be, in a Google Sheet or Excel, or you could use some, technology solution like Carta, when you have more shareholders or raising around. So that those pieces of the puzzle from the legal standpoint really go a long way to making the company look good from an investment standpoint, so that an investor can just go in and kind of check the box, making sure you have all these agreements in place, and it shows that you're thinking about legal strategy, and that often signals to investors that you're thinking about potential risks and liabilities, but also financial strategy. So what I see from well-rounded management teams is sort of having a perspective on all of these different areas, and those companies often are very successful in their dealings with investors and raising capital. So I'll stop there to see if anyone has any questions about sort of setting yourself up from a legal perspective for investors.
I do have a question around converting from an LLC to a C Corp. What are the steps involved with that?
Yeah, so sure, that's a great question. So it depends if you're in a state, like if you're converting to a Delaware C Corp, I'll use as the example because that's the most common. We do that all the time. It depends whether you're in Delaware LLC to begin with, or if you're an out of state LLC. So if you're a New York LLC, for example, and you're converting to Delaware, it's a sort of two-step process. You file a certificate of conversion and a certificate of incorporation in Delaware, and then you also file a articles of dissolution in New York to dissolve your LLC, because there's no one step to do that. But if you're a Delaware LLC converting to a Delaware C Corp, it's considered a statutory conversion, and it's a much simpler process. It can be done in one fell swoop. But really, overall, it's pretty, harmless process. It's not that painful, but it costs money. There's a lot of filing fees and the attorney's time. So it's a really easy way for a founder to save $300 to $3,500 for all of that, if they can got counsel on this issue in advance before signing up on LegalZoom and just forming an LLC, which is something I commonly see. But the process can be, to answer your question, Claire, it can be done, in under a week. If you want to expedite it, you could get next day a filed evidence from Delaware, and then New York usually takes a little bit longer to get the dissolution, but it can be a couple of days expedited, and like a week non-expedited.
Thank you.
Sure. Were there any other questions about that? Okay, so the next topic I wanted to talk about was common financing documents that are used in the investment process. And this is very different than other areas of corporate law. So having been a corporate lawyer that worked with, medium to large enterprise clients, working with startups is completely different, because there's, different nomenclature and different set of documents that you use for financings that you wouldn't necessarily use with a existing operating company. So the most common documents that I see in my practice and that other startup attorneys see for early stage financing is simple agreements for future equity, which are called SAFEs for short, which is developed by Y Combinator back in, I think, maybe 2013, and then about 5 years later they created a newer version of that in 2018 called the post money safe. And the other instrument is a convertible note, which has been around for a very, very long period of time. Essentially, the convertible note is a debt, a debt security that converts into equity, either at a valuation cap or a discount, and a safe. Well, I should say a convertible note, like a traditional promissory note, has a maturity date for use in startup financing. Usually see between 2 and 4 years for the maturity date, and we often see discounts used with convertible notes. The most common that I would see is a 20% discount, whereas with a safe, we often see a valuation cap or discount used. I would say more often we see valuation cap used, which is the maximum valuation that the safe would convert on in a Series A financing. So all of these documents, the convertible note and the safe, they convert in a priced round, and originally that was thought to be in a Series A round, but increasingly seed rounds have become bigger, and they become more like priced rounds in some instances, and so the safes and convertible notes would convert in that first price round, whether that's seed or Series A or what have you. At that time, the conversion of the safe or convertible note will happen at either the valuation cap that you've agreed on with your investors or the discount, which, as I said, is 20%. So let's say, for instance, in a Series A, you raised at $1 a share. The safe or convertible note holder would be entitled to 20% discount off that dollar. So their shares would convert at that 80 cents instead of $1. So that rewards them for their early investment in the company, and that's the whole idea of the safe versus convertible note. A lot of our clients in the last 2 years, I would say, have been using the safe to avoid issues of having a maturity date and interest accruing, because on the convertible note, like a traditional promissory note, the investor will invest their principal amount, but interest will be accruing until a conversion event or a change of control. So the safe doesn't have that. It doesn't have a maturity date. It doesn't have interest that accrues. And the drawback with the convertible note is, if you haven't raised within 2 years, you haven't raised your Series A, for example, and it's the maturity comes due on the note, you'll have to negotiate with your investors to amend their convertible notes, to typically leave them outstanding. Is usually the best resolution until they're a later priced round. So beyond seed, but as I mentioned, in some seed financings, we do priced rounds. You do a price round, in a Series A, where you raise capital at a fixed valuation. and you typically sell preferred stock to the investors in the deal, and often there will be a lead investor who will be a institutional VC, and then there can be other investors in the deal, whether they're angel groups or other VCs, other high net worth individuals, if you go that route. So that's the priced round. And the other common financing that we're seeing more of now, especially since the Russia's invasion in Ukraine, is crowdfunding. And we've really ramped up our capabilities in that area to meet our clients' needs. And we're currently working on a number of crowdfunding campaigns on sites like Republic and Start Engine, for example. And in those instances, you can either raise at a fixed valuation, like a priced round, or some of these funding portals will use a variation of a crowd safe, where you'll only have one entry on your cap table for, like, let's say Republic is the portal you use. You'd only have their safe on your cap table rather than 150 individual small check investors. So that's sort of a very high level of the typical fundraising instruments and process for early stage companies. Did you have any questions on that?
I do. In terms of crowdfunding, I was asked the other day why I haven't gone that route, and part of me is a little bit, in a first company, tentative about sharing too much data. Is that still legitimate? Is that still a concern with crowdfunding? Should I be less worried about that today than perhaps I was 8 years ago?
I mean, the risk is there. I can't say there's no risk, because you are putting information out there to a larger population of people who could potentially misappropriate your trade secrets and ideas and things like that. But the reality is, if you want to get people to invest in your company, you'll have to show some of the secret sauce. And there are disclosures involved with crowdfunding. There's a Form C where you have to provide, it's SEC Form C. You have to provide significant disclosures, financial, business risks, competition, things like that. So it's almost like a mini, IPO filing in a way. It's not as extensive as other types of SEC filings, but you will have to share some information about the business. But then again, if you were going to, institutional VCs, you would be sharing this information as well, and they rarely sign NDAs also. So, you run the risk kind of either way, but you're right, it is public. Somebody could register on the portal and, share your confidential information. That's possible.
You hear many complaints about that?
I have not.
Okay.
Okay, so if there aren't any other questions on that, I just want to, I get asked a lot about the entrepreneurial mindset from the perspective of representing over 300 startups now. And one thing that I really see in successful entrepreneurs is just that sort of that grit, that desire to keep pushing forward after challenge after challenge, obstacle after obstacle. But I think a lot of the successful entrepreneurs that I've seen have seen those challenges and can often look at them as opportunities as well, of coming to solutions, coming to deal terms with other parties and things like that. And I think in this environment, it's even more challenging to be an entrepreneur, because I think, you're always worried about, raising capital, keeping an eye on the cash burn. And, now in the sort of economic climate that we're in, and geopolitical environment makes it even more, I think, difficult on the management team. So that's something where I think, having a good group of advisors is also another thing that I've seen really help founders through these times, is working with operators who've been through different business cycles. And, just having advisors in general, I think, is something I'm a big proponent of. And I see successful entrepreneurs really go to advisors in different categories, having an advisor who might be knowledgeable about, finances and modeling, an advisor who has worked at or has raised capital before, or, worked in a C-level position at a startup that exited and has that operational institutional knowledge to, pass on to the current management team of, your current management team. So that's what I see from my perspective. And I think that it's can be a lonely job at the top, but, having that grit and that drive to keep going, no matter what, is really important. So I will stop there and see if there's any other questions. I'm happy to answer questions about anything I've talked about, or other startup questions you have, or things you've seen in the news recently.
No questions?
I'll ask. I mean, since you're here, we'll talk. Tell me, the biggest thing I see is yeah, it's a little bit lonely, being isolated and all the rest. You feel like you have a pretty good network, but today, getting even investment discussions, you really need someone to open the door for you. That's what I've found. Is that all about finding this investor who's raised money before, or this advisor who's raised money or specializes in that? Or have you got other ideas on how to kind of plow through some of these hurdles where people, it's the exception to get a meeting today as opposed to anything else?
Yeah, and I don't necessarily think that has anything to do with you or your company, but more market fundamentals. And, there's been reports that there's a lot of money on the sidelines, and I am seeing that with, some of our companies shifting to crowdfunding campaigns where they would have otherwise have raised in a traditional priced round. So I think, having advisors who, do have, connections and can make warm introductions is important, but it's equally important for you to identify who's investing in the space, who has raised funds and invest in the space recently, because these funds, have capital that they do need to deploy at some point. So why not stay on their radar, give them updates about what you're doing, following up? I mean, getting in front of them in one way or the other is really the most important thing. I don't really care how you do it, but I think obviously the first and easiest way is really, those warm introductions from an advisor or someone else in your network, obviously, but, other than that, there should be a target list of like sort of A, B, and C ideal investors that you kind of go after and follow up with. And a lot of my clients, do that, or in the habit of doing that, whether it was on my advice or just, their own, volition, and keeping that going, not just when they're ready to raise, but sort of taking meetings throughout the year in between raises, so that way when you reach out to a VC, it's not like, oh, hey, we haven't spoken in a year, but it's like, oh, I'm just following up on my update from 3 months ago where we hit 50,000 monthly active users. So it kind of focuses the discussion, and you're more top of mind. But yeah, I think that you're not alone, Kent. It is a more difficult environment, and it's been getting more and more difficult since February, March of this year. With Russia's invasion of Ukraine, and now what we're seeing with Fed's economic policy and economic policy, globally from different banks and central banks across the world. So I think a lot of people are in the wait and see posture, but I think that there is money out there, and it has to be deployed at some point. So why not get on people's radar so that you can get some of that.
Is that part of what you do?
Well, I'm a law firm, so I tell clients that first and foremost, we want to partner with you, take care of your legal needs, make sure you're protected. But we have a network of investors that we've met throughout the years and have networked with, and where it makes sense, I will make introductions. I just made an introduction for a client who's looking to exit right now. So we do that where it makes sense. I happen to know somebody in that space, and I introduced them, and now it looks like there's a deal to be had. But it's not something that like I'm not an investment banker anymore, so it's not my principal role. But where it makes sense, I'm always happy to connect people, and that's not just to investors, but also if you need an outside CFO or an accounting firm or something like that.
Okay. Thank you.
I think Sean has raised his hand.
Thank you. Could I ask a question about anti-dilution provisions for VCs? So we're just closing a pre-seed round at this time, and just from high net worth individuals. And so we're likely to move on to a VC round. We've already started conversations with a number of VCs. One of the things I'm probably most concerned about is what kind of provisions they typically put in to prevent their own dilution. And given the environment of sort of the caps in terms of what we've been seeing lately, and those presumably continuing to go down, I have some sensitivity to down rounds at some point in the future, based on the current valuations. So what do you typically see from VCs in terms of their language for what they put in to protect themselves against sort of dilution? And then mitigation for that from a investors or from an entrepreneur standpoint?
Yeah, well, typically what I would advise my clients is, we like to see follow-on, investments from VCs to show conviction. And I encourage, usually at some minimum threshold, that clients offer, pro rata rights to VCs, but I wouldn't recommend, and I would try to negotiate away anti-dilution rights where they just come as a matter of course from another financing round or a down round, because then it's just punitive on the company, and it may have nothing to do in this environment with the company's fundamentals or dynamics. So the same thing with the discount and anti-dilution provisions. I would try like hell to negotiate that out and offer pro rata right, because that will allow them to pay to maintain their percentage ownership in the company, whereas anti-dilution and discounts are punitive in down rounds. But with that said, the caps are down, valuations are down a little bit. So people are lowering those caps. So if you're lowering it, I think you have an argument to say that, hey, we're willing to go $1 million less on our cap, but we don't want any kind of anti-dilution provisions. And it also depends on what round you're raising. Obviously, if we're talking about a Series A, that lead investor negotiation will be a lot different than it should be in a pre-seed or seed round. Although, depending on the investor you have, sometimes they think that they're negotiating in a Series A in a pre-seed round. So it depends. But my position is to try to negotiate that away for my client.
That's helpful. I appreciate it, especially the pro rata portion. Thank you.
Yeah, because if that's the best thing you could show is, you have early investor who wants to maintain their ownership. It's a good signal to other VCs investing in your next round that you've had that conviction.
Thank you.
Ruby has a question.
Yes, Ruby.
Hi there. How
Hi.
do you put on that investor? Thank you so much, Neil. Your information has been very informative. How do you get on that investor's radar and get a warm introduction, get noticed?
Yeah, so there's a few common ways. First and foremost, I always say, I always advise people to kind of work backwards. Like, who's your ideal investors, and make an ABC list of maybe that ABC list may contain 50 total investors, and A is your top and C is your least relevant, and see what they've been doing in the news on Crunchbase, and then see look up some contacts on LinkedIn at that venture firm, and if they've invested recently in your space, or you hear that, or you see their portfolio companies in this that they've invested in or in your space, and you read that they've just raised some capital for an early stage fund, that would be a really good person to try or firm to knock on their door. And I would first and foremost go on LinkedIn and see if you have any connections at that firm. If you have any connections in common, ask for someone to help make a warm introduction. If you have an advisor, sometimes an advisor will reach out on your behalf, or they may have a warm introduction. But second to that, I think it's really cold, the cold introduction. If you don't have any connection to the firm, it's sort of a cold outreach with a personalized message, because these VCs, they need deal flow, they don't want to miss out. And you probably the response rate is probably going to be low, but you only really need a couple. And so I would do it in a very strategic way by targeting the firms that you want to invest in your company, and then try to get meetings with them. And if they don't respond after the first time, follow up politely. But whatever you do, keep everything personalized and not form, because nobody's going to read anything that's form. But you could say, hey, I just saw you raise this fund and you're looking for female and founders in the ESG space, and this, and like, you're ticking their boxes, right? Because they have a mandate. VCs and other investors, private equity, hedge fund, they have mandates to invest in certain things. So if you check some of those boxes, and you're aware of those things and you relate to them, they're humans at the end of the day, and it's building a relationship just like anything else. And I would do this early on and not just wait till you're raising capital. So you stay on their radar and be like, hey, Jane or John Smith, just following up. We just reached this level of whatever your important metrics are for your company, and you think might be impressive, and keep doing that. And I think that's really the way to do it if you don't have a direct connection to a institutional investor. Some angel groups have portals where you could submit your deals, and then I would follow up with the various angels. I know New York Angels has like Gus that you can use And then, you know, there's platforms like Thunder also, which I'm sure Ali could talk more about, that could link you up with, you know, vetted investors and things like that. But I think the, you know, the way to do it is build a relationship just like anything else.
Thank you so much. Ali, I'm going to need your help.
Yeah, we're a little bit more difficult only because we have that AI matching system, but happy to connect on the Slack channel. Okay, do we have any more questions? All right, if not, I think we'll give everybody back their 10 minutes. Neil, so much for your time and your knowledge. So helpful. It's not easy to find this information, I think, out there, and so it was amazing to have you with us and talking to our founders. Obviously, if there's any questions or so forth, feel free to follow up with me, and I'll get those questions to Neil. And other than that, I hope everybody has a great day.
Yeah, thank you for having me here. I appreciate it. And if you have any questions, just reach out to Ali or myself, and I'm happy to answer them.
Thank you.
All right. Thank you. Bye-bye.